Okay, we are live, everyone. Thank you for joining me. I've got a fantastic guest today, Larry Forman, the DUI guy. How you doing, Larry?
How's it going, Chief? I'm doing well. How are you?
Good. I've seen a bunch of your coverage of, well, particularly the videos you did breaking down the jury, your observations of the jury, and how you expected things to go. I thought you did a fantastic job. I really like watching those kind of observational breakdowns. Were you there all day today?
Thanks, man. Not all day. No, I left after lunch. I'm not gonna lie. It's been a pretty exhausting week for me. I mean, every day, you wake up, you go to court, you stream, you eat, you go to bed, and do that for like 4 days in a row. It starts taking a toll on you. So I don't know if you can tell by my face. I'm a little exhausted, but I'm feeling good. I left after the lunch break because I wasn't going to go back to the Weinstein trial. They were just doing jury instructions today, and they didn't really get all that much done. They pushed a bunch of stuff to next week, or the week when they come back, I should say, the 28th. Um, and the Masterson trial, again, I could have just sat there, but I figured I'm going to go back to my Airbnb, catch a little bit of rest, which is exactly what I did.
So I wondered, you and I've never spoken before right now. I know you're a
No.
practicing attorney, but I don't actually know. I was assuming you practice in California because you're there watching the trial. Are you is that where you practice, California?
No, I'm not licensed to practice law in California. I'm only licensed to practice law in Kentucky.
So are you there just for one or both of the ongoing trials?
Yes, I literally just came here to watch the Masterson trial, to observe and comment on the jury, because you don't need a license to practice law in order to get in the courtroom as public, or a media badge, because, like I said, I'm not coming in as a media person, although eventually I might on some of these trials as I make connections and whatnot. But yeah, and I learned Weinstein was literally across the hall on the same floor of the same building. So I'm like, well, doesn't take a genius to be like, well, since I'm already here, might as well double dip. Um, but yeah, no, I was just observing and enjoying myself, and then we got that bombshell today, man.
Yes. Tell me what you think about that.
I'll be completely honest. I did not expect that. I even posted my last two videos on Masterson, my two only videos on Masterson that are on my channel, the DUI Guy Plus. I said he's going to be convicted in 2 days. Like, I thought verdict was going to be today, like 100%. That was my guess, and I was completely wrong. The jury, I don't know what it is. I don't know if there's a holdout. I mean, there's a lot of chatter on the interwebs, on the grapevine, not here, but like on Twitter and stuff, that at least one of the jurors may have been tagged, if you will, by Scientologists or Scientology in general. And so they're like holding everybody back because we don't know what their split is. We don't know if it's 12-1, if it's 6-6, or are they like agreeing on some of the charges, but not all of them. We don't know anything. All we know is that they are deadlocked. And like I said, I wasn't there in the courtroom. I just read the reports that they're being deadlocked and re-reported them. And yeah, I mean, I'm sure Tony would have filled us in if Tony Ortega. He's been doing a lot of good coverage on this. He doesn't really talk to me, so I just kind of leave him alone. But I know he's been posting a couple of things today about the trial, and yeah, I mean, he would have filled us in, I think, if we had some details about like how they're split and so on. But doesn't look like we have a direct answer. But I'm shocked. I am completely shocked. It doesn't make any sense to me with everything that has been heard in the trial, from what I know, from the facts, from the closings. Just something doesn't smell right. But I'm just one person.
What did you think of the closing statements?
Oh, absolutely incredible. Absolutely incredible. I think Both lawyers, both Mueller and Cohen, did a fantastic job summing up everything that they had. I mean, Cohen did such a great job to the point where at one point the jury came back during deliberations and asked the question if they could look at some of his exhibits. And the judge said no, which was kind of interesting. Both the fact that they asked for it and that the judge said no. But Mueller, so I'm not used to prosecution being emotional. Usually it's the defense that brings out the emotion. Prosecutor's usually pretty dry. And what I heard from other people who have been in the courtroom during the openings, during the opening statements a few weeks ago, they said that in the beginning, Mueller was very, very dry. But now he has earned the right, if you will, to get emotional. Because all this testimony, and again, from what I'm hearing, the Jane Does 1, 2, and 3 sounded very, very believable and persuasive throughout the trial. And so Mueller, as an attorney, as a human being, understood that he has earned the right and was justified in arguing very passionately for the victims in this case. And it came off very well. It came off extremely well. Like I noticed one of the jurors even at one point, I have it in my video when I said they got emotional when Mueller said something. And one of the comments even later on, somebody said, it's very possible that they had like their own life experience where they tried to like bring somebody out of a bad relationship and that didn't work out or something like that. It was on that topic. So Mueller did a phenomenal job. And then Cohen, whom I got a chance to talk to a little bit yesterday in the cafeteria. I just ran into him and I introduced myself. He's a really nice guy. You know, as an attorney, I feel like I have a little bit more privileges sometimes, just a little bit, to talk to some of these people. Because like a reporter comes up to Cohen, Cohen probably won't talk to them because, you know, reporters are reporters. But myself being like a masked reporter, if you will, and an attorney, I can at least talk to them in the capacity of who I am rather than, because everything we talked about is off the record. I just shared the brief details and that's it, you know. I'm not going to share private information that he may or may not have shared with me. So there's this veil of trust between attorneys, which is really, really nice, that not everybody has a chance to enjoy. Unfortunately, I wish everybody could get that. But Cohen's closing, and I told him that when I met him, Cohen's closing was very powerful, very powerful. He's a very talented litigator. He's a very talented lawyer. And when you're given shit facts in a shit case, you know, there's only so much you can do. There's only so much you can do. And he understood that and he did everything he could with it. You've heard the term garbage in, garbage out. The same thing applies here, but he did not do garbage. That's not what I'm trying to say. He did a phenomenal job with the facts and the tools that he had accumulated throughout the trial. And of course, any defense attorney worth their salt will tell you when you don't have facts and you don't have law, you argue reasonable doubt. And that's exactly what he did. He went to, I think the first 20 minutes of his closing, which is an insanely long time, believe me. Doesn't sound like a lot, but a closing that lasts an hour and a half, like a fourth of it, he was just hammering home reasonable doubt. And I knew exactly what he was doing, and the way he was doing it was just amazing. I could not have done a better job myself. I absolutely loved how he approached it. And then, of course, he did get into the facts. His facts were a little bit disjointed and all over the place. He jumped back and forth between Jane Doe 1 and then 3, and then back to 2, and then back to 3, where, you know, it was very chronological. Jane Doe 1, boom, boom, boom. Jane Doe 2, boom, boom, boom. Jane Doe 3, boom, 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 conclusion. And then he opened with the law and then went through all that. Cohen's was a little bit more disjointed. Maybe it was strategic. Maybe it was, you know, scrambling of the brains is still a defense strategy, whether you like it or not. Trying to confuse jurors is not the best tactic in the world, but when you don't have anything else, sometimes that's what you got to do.
What did you make of the, I called it the scale. It's either the scale of justice or the scale of guilt or the scale of doubt. Do you know the exhibit I'm talking about?
Yes.
What did you make of that?
I wish I could use it in my own trials. But unfortunately, in Kentucky, we can't define reasonable doubt. Don't ask me why. It's just the way the law is in Kentucky. We're in a minority, I think, of jurisdictions that don't allow it. But it's what Aaron, is it Aaron? Or I know you joke around about it being Aaron from the Key and Peele skit, but okay, all right, it is Aaron. I just want to make sure. People are like, "Oh, you're going to see Aaron." I'm like, okay, what do I call him? Do I call him that? Or what do I fucking call this guy?
I'm pretty sure I'm going to get a sign up here on the wall that says Aaron.
Okay, and then you're going to confuse people even further. But hey, listen, it's your shtick. I'm just going along with it, man.
It started out as a joke, and now it's like the identity of my channel.
You should keep it. Fucking brand yourself. Aaron. Just remove the Smith-Levin and just be like, I don't know.
Just Aaron.
You know, Ron. And then like have a photo of Ron Burgundy or something. I don't know. Whatever. I forgot what the question was.
We were talking about scale of justice.
Scales. Yes. So what you're talking about is the and I've seen it to varying degrees. It's basically kind of like sometimes it's like a step ladder, and it's always you always have like 16 or 18 definitions essentially, and at the very, very top you have beyond a reasonable doubt, and next to it will say like definitely, like positively, absolutely guilty.
So to be clear, Cohen didn't create this thing. People keep telling me that it was used in the OJ trial. It sounds like you've seen many iterations of it.
No, this thing has been around for like 50 years, man. Like,
okay.
I don't know the original creator of it, but the problem is why I can't use it is it essentially defines reasonable doubt. At least I have not been successful in arguing that it doesn't. Because at the very, very bottom, you have like definitely not guilty, right? And that is correlated with absolutely not or whatever. And then you're like, well, probably guilty, possibly guilty. It is possible that they're guilty, probably guilty. I'm starting to sense like they're more than likely guilty, more than possible. And then it just goes up in scale until you get to and there's only one that's the beyond a reasonable doubt. That's the only time when a juror has the right to convict. And that's what the defense strategy with that chart is. Because if you're like, yeah, he's probably guilty, is still a not guilty, which is mind-blowing. But you have to bring in the legal definition, it's trying to separate your personal idea of what it means to what it means in the courtroom. And that is absolutely crucial. The fact that I can't do that, trust me, I may have lost a trial or two just because I wasn't able to bring that in. But it is what it is.
Let me ask you this about that. Do you think it's a mistake for the prosecution? Because the prosecution was able to have the last closing, right? The people go and then defense goes and then the people go.
Correct.
Not to have taken the opportunity when he was having the last word to revisit with the jury this concept of guilty versus not guilty, because Cohen succeeded in allowing the jury to believe that guilt is a spectrum. And the truth is, you're either guilty or you're not. Doubt can be on a spectrum, but you're either guilty or you're not. And whereas I think the scale is probably most accurately defined as the scale of doubt, I think Cohen succeeded in the jurors thinking, oh, you can be kind of guilty, but not guilty.
I think So the way Mueller approached it is slightly different. He took the word reasonable. That's what he latched onto. He did exactly what you just said, Aaron, and he latched on to the word reasonable, and he wrote it down. This is the one word. Basically, forget everything else. Remember, when you go back to deliberate, this was literally what he ended on, like 3 minutes before they went back to start deliberating on Tuesday afternoon, Tuesday evening. He said, he wrote the word reasonable. And then he did something catchy. I'll just fast forward real quick. He took a board and he hid the portion of the word, the ABLE were not visible, and all you could see was reason. Very, very tactical, very smart. Definitely not an accident that happened. The point of him going into that was, sure, the defense have argued this whole guilty, sort of guilty, kind of guilty, maybe guilty, probably guilty, without talking about it. But the bottom line is, at the end of the day, what is the language that the court gave you? Beyond reasonable doubt. Reasonable. Your doubt has to be reasonable, and it has to be beyond any reason to have this doubt or whatever. You can't, I mean, you could have a far-fetched doubt that aliens came down and implanted this idea. He didn't say that, but that's basically what it means. Planted this idea in Jane Doe's brain, and it never happened, but aliens, man. You know, remember that meme? What happened here? Aliens, right? So you could, but it's not reasonable. It's not reasonable. So that Mueller, I think, it may have been stronger. He may have had something better, but I think he did a good enough job to where here's the bottom line. Let me just put it to you this way. Here's the bottom line. And I don't know about California jurors. I know about Kentucky jurors, and I know about Kentucky jurors in different counties. Jurors in some counties in Kentucky will nullify, either in your favor or against you, completely ignoring the law. Usually because I go to these places where, like, the highest grade of education completed is 12th grade, if you're lucky, amongst 100% of my jurors. I mean, I've been to places where the highest level of education they've completed, it was like 8th or 10th grade, you know, and then they drop out and they start working, and now they're in their 40s and 50s, and they've been working all their lives. There isn't as much processing of information. It's just very, very direct and oversimplified, which is very difficult and very dangerous when you're a criminal defense attorney. And when you don't have much to pick from, then you're in trouble. I don't know how California jurors are, but what I'm very, very particular about is I'm wondering, as they're deliberating, jurors don't talk about the law. They talk about the case a little bit, but each juror usually brings in their own personal experiences into the courtroom, and they'll start talking about them. Like, my cousin's sister's brother's uncle's father's son had a similar scenario. And then they'll just start talking about it because this is what I'm familiar with. And that's how I can analogize to what's happening here. And this is the only way I can make sense of the situation, because, you know, there are some who will try to analyze, like, what do these instructions mean? And especially in California, your instructions are like, I'm falling asleep, yo. They're so long and comprehensive. And I have a legal mind training, and I'm still having trouble with it. I don't know how simple people with no legal education are supposed to be analyzing this kind of shit. You know, when I say simple, I don't mean like simple-minded. I mean not legally educated.
Have you heard any of the chatter there? I don't remember if during the voir dire process, if these jurors were asked what their professions were. Have you heard whether there's an attorney on the jury?
I don't think there's an attorney on the jury, as far as I know. I was not there during voir dire, and I was not informed about the details of voir dire. But let me just finish my thought before I forget to answer your question finally. the fact that they hung, by the way, it tells me, well, they didn't hang yet, but they're deadlocked, which is leading towards a hanging. A hung jury is a jury that cannot decide. That leads me to believe that I personally think they're not understanding the instructions or anything crazy like that. They understood the instructions. They just can't decide. They either have a couple who are like, I don't believe the women, we should acquit. Probably one or two of those. And then we have about 9, 10, or 11 who want to convict, but they don't know 1, 2, or 3, or 1 and 2, 2 and 3, 1 and 3. It's a lot of stuff. It's a lot of stuff. But I think there's about a 90% want to convict on something. They can't decide. They can't decide. And they're going to take this week and a half, really, to process, think this over. They have 10 days. They have 10 days until they come back. November 28th, jurors are coming back to deliberate. Between now and then, I have a very strong feeling that they talked amongst themselves and said, look, think about it. Reprocess the information that we received during the trial. Let's come back, maybe do a vote. If anybody has a change of heart, we all want to get out of here. The jurors always have that conversation. We all want to get out of here, don't we? We don't want to be deliberating for the next however many days or weeks, right? So let's stop here. Looks like we can make a decision. Let's go back home, not watch any news. Of course, they've been admonished by the court. Do not read any articles about it. Do not watch any movies. Do not watch that 70s show that could be, Danny is in, blah, blah, blah. Try to avoid interference as much as possible so it doesn't affect you in your decision-making in this case. And then we're going to come back and then we're going to start talking about it again. I do not believe that they are split evenly, for example, like guilty, not guilty, like 6-6. I don't think so. I think there's a straggler in there, or if there's no straggler, then it's very possible that maybe all 12 of them are in agreement. They just can't decide which one to convict on. Not likely, but possible.
If you've got heels dug in on both sides, and you've got this 10-day break, which side of this argument do you think is more likely to relent in order to get this case over with? Someone who's leaning to acquit, you think they're more likely to relent and go with the other side, or vice versa?
Vice versa. Usually the side that's, you had a few layers there. Let me just make sure I'm clear. The side that wants to acquit, if they're in a minority, will likely give way to the side that will say to convict and then maybe do some of the lesser charges. Juries are huge fans and proponents of splitting the baby just so that they can agree. But sometimes, like you said, you have people who just dig their heels in and they may say, look, not guilty on all 3 counts, fucking sue me. I don't know what you want me to do. This is what I believe. And I'm like 12 Angry Men. This is, I always allude to it when I talk about juries. Henry Fonda, 11 people. Come on, man. We just want to go home. Will you just sign on the... No, we need to talk about the evidence. That movie takes it to an extreme. Of course, if you've seen it, you know what I'm talking about. But the reality is not too far from it. You may have an individual who's again, like I said, the chatter on the vine is maybe they're bought and paid for somehow by the Scientology community. You never know.
Well, I'll tell you, if it comes back 11-1, someone's got some splaining to do. So, I've been of the opinion that there's no way that Scientology is going to put its ass on the line for a piece of shit like Danny Masterson. Not even the Scientology executives give a shit about Danny Masterson. That they will protect him if they think that it will protect themselves. But that's what they've been doing for the past 15 years. They're not interested in getting involved in obstruction or witness tampering or jury tampering. That's really not Scientology style to this day and age, unless they're doing it for Tom Cruise or for David Miscavige, not for just some schmuck like Danny Masterson. Now, that doesn't mean Danny Masterson couldn't be working out some shenanigans behind the scenes. I mean, I never put anything past anyone when it comes to, I mean, look, he's facing minimum 45 years is my understanding.
Correct.
That's the minimum.
On all, if he's found guilty on all 3 counts, I believe.
Oh, so if it's only 2, it would actually be okay.
Less. Yeah, but it's okay. Up to life in prison.
Right.
Is the maximum.
So, man, we've got to sit with this for 11 whole days before, 10 before they come back, but then they're not going to come back Monday and be like, just bang it out right when they get in. Everyone's going to be sitting around for at least an entire day. So actually, let me ask you this. Let's just assume that we've got a holdout and this thing's going to hang. How much longer do you think Judge Almeida will make them deliberate when they come back on the 28th before letting him off the hook?
We have something in Kentucky called an Allen charge. Allen, because it comes from a case, Commonwealth versus Allen. And then in Allen, the issue was the jury was deliberating and the judge released them too quickly. And the Court of Appeals said, if jurors can't agree, it is the judge's duty to send them back and say, try to agree. At least try. Like, try again. See if you can come to a consensus. And sometimes they'll Allen charge a jury a couple times before the judge will be like, all right. Now, it depends on the situation. I had a case, for example, my only hung jury in my career, they were hung 3-3. It was actually that one rare scenario where I had 6-0 in my pocket, but the prosecutor scrambled their brains a little too much, attacked me personally, which to this day, it was kind of like a veiled compliment. He called me like the best DUI attorney money can buy, and he didn't do this. So I was like, thank you, you piece of shit. It's a very weird, how do you object to that? Like, objection, Your Honor. He's talking about me truthfully. Stop it. But he just eventually he was able to buy about 3 jurors with a few facts in closing that he pointed out, which was completely inappropriate. But they hung. We ended up winning the case later anyway. But they hung 3-3, and the judge was not going to Allen charge them because there was no point. They couldn't. They were completely deadlocked, split down the middle. I don't know if California has something similar. Again, I'm basing a lot of my thoughts on hearsay, which is a problem because I don't practice here. I don't know the laws here in California. But if you have anything similar to an Allen charge, then that should be implicated in a case like this, unless they are 6-6, for example. And again, you got to remember, and this, I just keep coming back to this in my head because it's the only thing that makes sense, is they could be 6-6 right now as we speak, but they're not 6 guilty, 6 not guilty on all counts or whatever. It's possible that they are deadlocked on, 4-4-4. 4 want to convict on Jane Doe 1, 4 want to convict on Jane Doe 2, 4 want to convict on Jane Doe 3, but they can't agree. They can't all agree on which counts to convict on. That's right. A very real possibility, and that would be the ideal scenario for the prosecution.
Does the judge ever get an opportunity to find out when the jury says we're stuck? Does she ever get an opportunity to find out, or the attorneys or whatever, like what the breakdown is mathematically, like what you've been describing, or is that no transparency into that? Like, because if she knows it's 11-1, I feel like she's more likely to be like, get back in there. But if they keep coming back 6-6, but I feel like if they were going to tell the judge where they were at, then we would have heard that today, wouldn't we?
That's a phenomenal question, Aaron. And here's how I'm going to answer that. This is probably closest to the truth. The judge, if today was like Monday, for example, we would have probably known a lot more information. Because let me put it to you this way. The way the court handles a situation, the way lawyers handle a situation, the way prosecutors handle a situation is all dependent on the circumstances surrounding the situation. So you can't look at a case in a vacuum and be like, well, if this happens, this is how we handle them. We're on a Friday before Thanksgiving week with a 10-day break. I think the judge, because the more that it's a sensitive game to start prodding into the jury's thoughts and feelings. Because you definitely, the last thing you want, and this is probably grounds for a mistrial and definitely grounds for appeal, if let's say the judge kind of like pushes them like, you need to go decide anyway, like we're running out of time, we all want to go on break or whatever. You can't do that because now there's an appearance of impropriety and interference with the jury process. That's the last thing you want. But they're also not thinking in a vacuum, right? So the reality is it's a Friday before a 10-day break. It's Thanksgiving. I think the judge figured, as well as the lawyers, less is more. So by giving the jurors an opportunity to just say, like, look, we can't decide, Your Honor, we're deadlocked. And the judge is like, okay, how about we just take a break, come back Monday the 28th, see where you guys are. And just left it at that. That's a very smart. Judge Almeida, by the way, is extremely intelligent. I absolutely adore her. She maintains control in the courtroom. She understands these little intricacies. She seems like she's right on the ball. She's right on the money. And I think it was a conscious strategic decision to be like, don't worry about it. I understand. At the end of the day, you only deliberated for like 2.5, 3 days now. So it's okay. Let's come back, give you some time, think it over. And then if Monday and then Tuesday they come in, Your Honor, we're still deadlocked. Now we can open Pandora's box. Okay, so what can you tell me? Well, Your Honor, we can't decide based on this. And then the judge can act accordingly and give them an instruction. Because you never know. Just because we're deadlocked doesn't mean that we are not going to come to an agreement in a couple minutes, a couple hours, a couple days, 10 days, whatever.
Right.
So there is no, in the legal realm, there is no such thing as a definite when it comes to, especially when it comes to jury analysis and when it comes to just dealing with juries for the court and the lawyers in general. So I hope that answers your question.
No, it definitely does. Let me answer a couple questions I see right here. Do you think Danny Masterson is still practicing Scientology? Do you think he's been interrogated for all the trouble he's caused? Yes, and for sure, yes. I mean, in the sense that he's still a Scientologist in good standing. Scientology is not like being a practicing Scientologist isn't like being a practicing Christian. Being a practicing Scientologist just means they haven't declared you a suppressive person. And when someone asks you if you're a Scientologist, you say yes. Other than that, Danny's never really been much of a practicing Scientologist, but he sure as hell has been interrogated for all the trouble he's caused. Let me see. I know there's another one here. And if I don't forget it, I know there's another question I wanted to ask you. Oh, well, this is awkward. There it is. Okay. Interesting that the term reasonable is used. Larry, you may not know, but reasonable is a kind of it's a very specific word in Scientology that's actually been redefined as a negative term. Calling someone reasonable is actually an insult in Scientology. Did you know that?
I had no idea.
It means coming up with excuses why something is okay when it's really not okay. It's a slur in Scientology. Those are fighting words, calling someone reasonable. And actually, if you ever watch Tom Cruise's crazy black turtleneck video where he's talking about KSW and putting in ethics and all that shit, do you know the video I'm talking about?
No.
It's the video that made Tom Cruise it's like his famous Scientology video.
I just remember him jumping up and down on Oprah on couches and shit with what's her name? I love this woman. I love this girl. That's what I remember.
Oh, Okay, I can't believe you've never seen Tom Cruise's black turtleneck video, his Scientology. It was an internal Scientology video that leaked. So he's talking in Scientology. He's using all his Scientology speak, and you know knows what the hell he's talking about. Anyway, he uses the word unreasonable because he goes, I'm unreasonable in putting in ethics on others. So that's a good thing.
Gotcha.
There's
Okay.
your
You learn
Scientology
something
lesson
new
for
every
the day.
day.
Okay, what do we have here? Allen versus U.S. came out of Arkansas, all states.
Oh,
Yes.
well, there you go. Maybe that's the one. I honestly have no idea. I just, my associates do all the dirty work for me. I just kind of use it in court these days.
Yeah, I've been seeing a lot of comments and emails about the Allen charge.
Yes.
I think Quo Valdez called it also the depth charge. I'm not sure if that was a joke or if that's lawyers understand what that means. Uh-oh, wait, what's that? Okay, what is the problem with DM testifying? Could he just lie like many sociopaths before him? I've seen a pretty general consensus that it would be crazy for Masterson to testify, and it's totally normal not to testify in your defense. Would you agree?
Yeah, especially in a case like this. I mean, the problem with criminal cases, defendants testifying in criminal cases, is that if you did it, you probably don't want to talk. And sounds like he did it, and putting him on the stand will definitely put the last nail in the coffin. And it's, even though jurors will interpret your failure to testify, even though they're instructed by the court that they cannot use your failure to testify in this case against you, jurors are humans. Humans like to hear everything. By not hearing everything, their decision-making process is a little skewed against you. But if they're to follow the law in a vacuum, then they won't let the defendant's failure to testify interfere with their decision-making process as to guilt beyond a reasonable doubt. It is a legal fantasy, but it's out there. And we have seen, like, look at O.J. Simpson, the most classic example I can think of. Everybody thinks everybody knows, right? Everybody thinks they know. Everybody think they know. Everybody know that they think that they know that they think that they know that he did it. And yet, after 9 months of testimony, they acquitted. So, can the legal process be used as a shield? Sure. Most often it's being used as a sword, and jurors are very unforgiving, especially when the testimony is so damning. After everything I know and after everything I've heard, I simply refuse to believe that the Masterson jury has an even split or something with respect to guilt or innocence. I think they just can't decide which ones to convict on. That's my own personal opinion. And it probably is the right one.
I hope that's true. If the jury is hung, will Danny Masterson beg for a plea if he's out of money? Yeah, I don't know what happens when you're out of money and you need a criminal defense attorney. What does happen?
You hire the public defender.
I guess, right? Yeah, I don't see Masterson pleading out.
The prosecution will retry it. He'll make him start over.
Yeah. Would a mistrial be a win for Scientology? Personally, I don't think so, and I don't think Scientology sees it that way because Scientology is not on trial. Scientology policies and procedures have kind of been exposed, and it makes Scientology look bad. But Danny Masterson being found guilty, honestly, doesn't make Scientology particularly look bad here, and him being found not guilty doesn't make them look good. The fact that Scientology, tells its members that if you go to the police when you're the victim of a crime like this, you're going to be expelled and lose your family. That's out there in the public. That's true, no matter what the jury decides. And so I think Scientology doesn't honestly care at this point which way the verdict goes. That's kind of my take on it. Well, we've been going for 40 minutes. Why don't we leave it here for now. Are you going to be back in the courtroom in 10 days, whatever it is?
No, I'm going back home, and I will not be coming back to this trial, unfortunately. But I will definitely be keeping an ear to the ground. I now have people, that are here, so I'll be in touch with them, and I'm looking forward to seeing what California has to offer in the future.
Nice. Well, thanks for coming on. It's been a real pleasure talking to you, and hopefully we can do something again soon.
Likewise. Thank you, Aaron. Thanks for having me. Or excuse me, Aaron. Thank you for having me.
Thanks for watching, everybody. Have a good night.
Thanks, Chad. Have a good night.